Hello, Brian Weeks here again with another MMCD contract consideration. This video clip will cover the topic of the roles of the contract administrator, or CA as I sometimes say. Because of its inherent conflict of interest, the role of the contract administrator is probably the most difficult and important role of all the participants in the contract process. The MMCD Association chose the name Contract Administrator very carefully. We wanted to be clear that this role was not that filled by the engineer as in the past. There were too many contracts written where the engineer had the final say, a situation that led to a lot of income for lawyers. More importantly than that, we envision the CA's role as the linchpin of the project. The CA is the focus of all communication between the owner and the contractor. And the CA performs duties for the owner that no one else can do, such as approving progress payments, change orders, and certificates of performance. The CA acts as the initial evaluator of the performance of both parties to the contract. Probably the most important aspect of the CA's role is that it really is three roles in one. I call it the three-hat problem. Number one, in the first role, the CA is the owner's representative on the site. In this role, the CA has a duty to protect the owner's interests in all aspects of quality, record-keeping, schedule, and payments. Number two, in the second role, the owner has agreed to put the CA into a position where he or she must act impartially to, quote, evaluate the performance of both parties to the contract, end quote. In the third role, the CA may be a representative of the firm which did the design of the project. In this role, the CA must ensure that the construction of the project does not compromise the design assumptions and parameters. Given these three roles, conflicts of interest are, unfortunately, inevitable. This situation becomes even more difficult when the CA is a representative of the owner or the design firm. One thing I've not mentioned is who can be a CA. The answer is that the owner can appoint a CA from its own staff, from the design firm, or from some other independent third party. MMCD does not make any recommendation about which source the owner should use because every situation is different. However, due to the inherent nature of the conflict among the CA's roles, I recommend that the owner issue some form of letter of understanding to the CA when that person is appointed. This letter should indicate that the owner understands and recognizes that the potential for conflict of interests exists, and he expects that the person appointed to be the CA will act impartially as is required by the contract language. This is particularly important and valuable when the CA is one of the owner's direct employees. It's important to stress one other point. The CA is a person, not a company. It is essential that the contractor know specifically whose signature is authorized to make changes to the contract, to authorize payment, and to evaluate quality. This relates to one of the fundamental concepts underlying the MMCD, that the CA signature is good as gold. That is, once the contractor has the CA's signature on a form, it cannot be arbitrarily withdrawn without risking a dispute. Back to the three-hat problem. First, let's consider the role as representative of the owner. GC 3.1.1 makes it mandatory for an owner to appoint a contract administrator and to advise the contractor in writing, not later than the notice of award. Furthermore, GC 3.1.2 makes it mandatory for the owner to immediately replace a contract administrator who departs. This emphasizes the importance of the role of the CA in the project. The project should not proceed without a CA in place. GC 3.2.2 makes it clear that the contract administrator only has a contractual relationship with the owner. But that's a separate issue than the duties that the CA owes to all parties as part of the CA's job. GC 3.3.1 outlines the general requirements of the role for the owner as, quote, providing administration of the contract, unquote, and sets out the date that the role finishes, that of total performance. A key point here is that the owner, by signing this contract, has delegated a number of responsibilities to the contract administrator. The owner may not take them back by arbitrarily overruling a CA's decision without risking a dispute. Now, let's consider the role of the CA in representing the design firm. It's often the case that the owner and/or the design firm will want the CA to be from the design firm to ensure that the design concepts and assumptions are not compromised. This is perfectly okay under the MMCD and makes a lot of sense. However, because the engagement of the CA is a separate function, which is not part of the construction contract, the MMCD does not provide any language in the construction contract related to this matter. While we do provide a separate contract form for this role, those matters are between the owner and the design firm, not between the owner and the contractor. Even when a CA is appointed who is not from the design firm, the CA has an obligation as a construction professional to involve the designer whenever the CA has concerns about design parameters or assumptions. If the CA works for the design firm, finding a problem with the design can put the CA into a conflict of interest between his or her duties for the owner and those for the design firm. The proper way to deal with this is to recognize that in accepting the role as CA, the first obligation is to the terms of the contract. The design problem must be fixed, and there may be resulting costs from the contractor to the owner to perform the fix. If this reflects badly upon the design firm, that cannot be helped, but the CA must not let that factor into the decision to do the right thing. Finally, let's consider the difficult role of impartial arbiter. It's in this role that the CA faces the most difficult issue of potentially rendering decisions with which the owner may not agree. GC 3.6.1 is written both to describe the role and to protect the CA when making unpopular decisions. There are three key elements to this clause. Number one, the CA makes all decisions in the first instance. This means that all decisions are subject to potential review under the dispute resolution process, providing one party files a formal dispute notice within 10 days. Number two, the CA must make an evaluation of the performance of both parties to the contract, not just how the contractor performs. And number three, the CA is explicitly told that in making that evaluation, he or she must be impartial. This is the protection I mentioned. By choosing to use the MMCD documents, the owner has agreed to this role and its requirement for impartiality. Obviously, if a contractor complains to the CA that the owner is not following the contract, and, after investigating, the CA agrees, then there may be consequences which the owner would just as soon not encounter. Let's consider a couple of examples. Example 1. The agreement states that if the owner does not pay on time, the contractor is entitled to interest on the delayed payment. However, the only way this interest can be authorized is for the CA to include the appropriate amount on the next progress payment form. This obviously puts the CA's duty to be impartial at odds with the owner's desire to minimize extra costs. Example 2. Suppose the owner's inspector promised to be on site at 8 a.m. to check piping details before the trench is backfilled, but does not actually arrive until 12:30 p.m. If the contractor files a delay claim, the CA must evaluate its validity and award both appropriate costs and possibly a part-day time extension. Again, this is clearly not in the owner's interest. However, not only is it fair, but it's also required by the language of GC 3.6.1. So, to summarize, the role of the CA is so critical that the contract should not proceed without one in place. The CA can be sourced from the owner's staff, the staff of the design firm, or an independent third party. Any way it's done, the CA is a single person, not a firm. The CA wears 3 hats during the project: representative of the owner, responsible for project administration; impartial arbiter of the performance of both parties to the contract; and at least partly responsible to the design firm to maintain design integrity. These roles have inherent conflicts of interest, which cannot be avoided. The CA must follow the exact terms of the contract language when making decisions. The MMCD Association has attempted to protect the CA by having the owner agree to the need for impartiality and by making all decisions of the CA available for review under the dispute process. I hope this has helped clarify this contract consideration. Please check our website for further assistance and to see what other topics are presented in this series. Thanks for watching.